Welcome again to our last part of when is a product defective, because you see the circumstantial situation that makes the product defective. It's not necessarily if the manufacturer did it or anything like that. Just the fact that the plaintiff is injured, and that's what makes product liability very interesting. And this part is really more interesting. And of course, I'm starting the question with should, which is ethics, not law. Should consumer recover damages for harm caused by their own carelessness? This is the people, they're careless. Or product misuse, or for accidents for which no one is at fault. The person just got hurt. And government has regulation. We have different agency regulating, and the Food and Drug Administration, EPA when it comes to smoking, the Department of Transportation when it comes to travel, to vehicle and cars, the selling information when we're going to cover in the next lecture. It's very, very interesting, always for the safety of the society at large. Public policy. The record of direct government regulation of product safety is as best as spotty with a major independent regulatory agency. We know that we have the government testing cars, airbags, tires. I mean, almost every product gets tested before it goes in commerce. The thing is that we don't have that many people testing these products, so some products goes in the market before the government has a chance to test it. Very, very interesting and very. The Food and Drug Administration is the biggest agency apparently that is protecting Consumer Product Safety Commission and the Environmental Protection Agency, often facing criticism from both business and consumer interest. Very often because they are to protect consumer. And to what extreme? Where is that fine line that business says enough is enough? There is such a thing as the plaintiff or the consumer, should have better sense. But remember, there is no common sense anymore. People are more and more relying on the instructions of the computer or the label or the news or the expert, legal expert or a terrorism expert. The CIA, the FBI, I mean, even the president, I'm sure, makes decision on the information he gets from other people because we have so much out there, so much knowledge, so much information. There is a need to impose strict liability standards on manufacturers to prevent unsafe products from entering the marketplace. This goes back to the EPA standards of environment. The EPA sets up standard how much a company can pollute. And what really the government is trying to do now with product safety is set up a standard when is a product safe. Does not mean that nobody will get hurt anymore. It's just that there will be a standard so that the company can relate to that standard or can apply that standard and minimize lawsuit. There is a fine line, however, between an imposition of ethical standards on manufacturers to benefit society and one that has the effect of overprotected consumer. Very fine line by setting up the standards, because nobody wants to see anybody getting hurt. And in our society that we are affluent and it shouldn't be much to pay another dollar for the product or spending more money on research before we send the product on commerce. It shouldn't be that difficult to do it. And sometimes the court used that argument. The company, you put a product on commerce that if you would have done a little bit more research, or if you would have think of another alternative cheaper than the injury, you wouldn't have this lawsuit, this liability. In one case, a young boy fell through a toilet seat and suffocated in the water. He was like about 3-4 years old. His parents sued the toilet seat manufacturer for failing to place on the lid a sticker to warn parents to take protective measures, such as buying a lock for the lid or installing self-closing hinges on the bathroom door. And I saw in Home Depot some toilet, exactly that. warning parents and setting up inches so that even their dog does not drink water from the toilet. The fine line, the manufacturer agreed to pay $90,000. Now, $90,000 will never bring that little boy back to alive again, but apparently we as a society feels more comfortable or accept that kind because it costs something to the company. So it's not fair. At least the parents with $90,000, I don't know, they can adopt another child or whatever. Many persons might question the ethics of requiring a manufacturer to warn of an obvious danger. Obvious dangers. I mean, come on, you know, how stupid do you think I am? And some of them I could be reading to you that you probably never bothered, but I wish you would. And on a Sears hair dryer, for example, do not use while sleeping. I mean, geez, you know, when do I use my hair dryer? On a bag of Fritos, and I know you could be a winner, no purchase necessary, details inside. Well, if there is no purchase necessary, how can you get the details inside? Because you have to buy it to get the details. On a bar of Dial soap, direction, use like regular soap. Well, what else are you going to use the soap? On Tesco tiramisu dessert, it's printed on the bottom of the box. Do not turn upside down. I mean, what, the box or the dessert, what? On Mark Spencer bread pudding, product will be hot after heating. On a packaging or a wet and iron, do not iron clothes on body. I guess some people must have done it. On Boo Children cough medicine, do not drive a car. Now, children do not drive a car or operate machinery after taking this medication. And of course, the child drive the car. We have problem even without him taking a children cough medicine. Nightal sleep aid, warning, may cause drowsiness. On most brands of Christmas lights, for indoor or outdoor use only. I mean, how many other way can you use these Christmas lights? On a Japanese food processor, not to be used for other use. What is this other use? On a Sainsbury peanuts, warning, contains nuts. Well, this is why it's peanuts. On an American airline packet of nuts, says instruction, open packet, eat nuts. I mean, are you supposed to eat the packet without opening it? On a child Superman costume, and you probably saw this, but you never thought of that twice. Warning of this garment does not enable you to fly. This is warning to parents because the child wears the suit. He's not going to read that. On a Swedish chainsaw, this is something that you're going to laugh. Do not attempt to stop chain with your hands or genitals. On a bottle of palm olive dishwashing liquid, do not use on food. There must have been people that use these things. And of course, on a bottom of a calico butane lighter, do not use near fire or flame. I mean, the lighter is fire and flame. And of course, if I go back to Mr. Coffee, which I will attach the decision of the court, McDonald Coffee, I mean, the whole thing there that happens to discovery, I mean, everybody knows the coffee's hot. Now McDonald has to put that this is hot coffee. The reason was because their coffee was hotter than the standard imposed to the industry or the restaurant industry, and their coffee was hotter than all the other restaurant industry, or if you want to call food industry. And because that was one thing, and then the reasoning why their coffee was hotter than the standard required by the government for all the restaurant industry is because the hotter the water, the less coffee grind you use to make coffee. And that definitely it's unethical, and the court therefore made McDonald liable for the coffee. And that's why they have to warn you that their coffee is hot, because it's hotter than the restaurant industry. Very, very interesting. And I will put the discussion or the opinion of the court on this discussion board. So these are the things that we have problem as a society. The fine line. What about studies that have shown that people care less about how good their coffee tastes than it is hot? And of course, that the coffee was making hot. Should tobacco liquor companies be liable for the premature death of a person who used tobacco or liquor products because they are addicted to these drugs? And you're going to see more and more now that even liquor company will be liable because alcoholism as an ordinary disease, and if there's some way that we can stop that, it's very interesting. No one is forced to become a nicotine addict or an alcoholic, and virtually no one is ignorant of the detrimental effects of consuming these drugs regularly. I mean, we have warning on cigarette that this may cause cancer, and I asked a couple of teenagers, why you continue to smoke, and they believe that science will come up with something that will heal the cancer. In the meantime, and who knows if they're going to live that long until 80 anyhow, because of nuclear weapon threat and all the other stuff. So it's very interesting. Warning on a warning, they're going to choose what they want to do. In your textbook, the American tobacco case is a good demonstration of how the company argues that the smoker contributed to his own illness. If we go to the fences again, they're assuming the risk. We have a warning. We tell them that it's going to cause, and I have to tell you that it's interesting because even perfume, it's alcohol. A lot of our products, my colors is chemicals. Another good argument is the cigarette smoker knowingly assumes some risk of lung disease. They knew that it's dangerous. They know that you're going to get addicted. Kids will say, yeah, my parents told me not to smoke, but they smoke. You know what I'm saying? So when I did a little survey, it was amazed me how each one of them had plausible, but not necessarily true reason why they were doing what they were doing. So how did the court decide in that case? Do we have free choice in a free society? So that if we choose to continue to smoke or buy a cigarette, then shouldn't we then be responsible and liable and not the tobacco company? And also, doesn't the tobacco company has freedom to come up with new products to make society better? And if we choose to buy them, why is it that they become liable? Can they ensure that every product that we're going to use will not hurt us? This is the question that I want you to think about it. Do we really have free choice? Do we really know what we're eating, what we are smoking, where we are walking, on what we are sitting? If cigarettes cannot be made safe, then does not mean that they should be illegal. Something for you to really think about it. And I'm very happy to hear or heard that the Food and Drug Administration wanted to legalize nicotine as the drug. And if the court were to say yes, the Food and Drug Administration can regulate nicotine and become a drug, then the smoker would have a legal action under the American with Disability, because it's a drug and therefore you're addicted to that drug. And of course, if that means that the cigarettes are safe and they become illegal, that means you smoking cigarette, you are using an illegal drug, and it just opened up a can of worms. And I'm pretty sure that's why the court decided not to have the Food and Drug Administration regulate nicotine. Who should be held liable for harm caused to non-smokers? Now, I never smoked all my life. My parents did not smoke. My sister doesn't smoke. So what about non-smokers that are traceable to cigarette? Some of you, the spouse maybe smokes. What about in the office? And then should the employer liable because a coworker smokes and I end up with lung cancer? The EPA, the environmental agency, has recognized that the risk associated with environmental tobacco smoke are at least an order of magnitude greater than they are for virtually any chemical or risk that EPA regulates. So here is EPA regulates smoke because of the environment. What about the drug nicotine? Indeed, it is one of the most addictive drugs, and Americans have long known of its addictive qualities and harmful effect. Should Americans have a right to derive pleasure from products with side effects that include an increased risk of serious illness? I mean, if we think about it, prescriptions advertised on TV, it's amazing to me how they tell you how, that will help you to lower your cholesterol, but then they give you about 15 side effects, like, your liver, your heart, whatever. So you wonder sometimes, maybe I should continue to have my high cholesterol. In 2000, the tobacco company sued the FDA claiming that the agency had exceeded its authority under the Federal Food, Drug, and Cosmetic Act of 1938 by attempting to regulate nicotine as a drug. The United States Supreme Court ruled in favor of the tobacco companies so that nicotine is not a drug and it will not be under the regulation of the government, and the government cannot set up a standard in that area. Another difficult fine line to draw is the line between abnormal and expected use of a product, or between expected and anticipated use of a product. A seller may defend itself by proving that the consumer use of its product was an abnormal one. You know, like, I don't know. There are some products that some people think is very creative that they can use it. I mean, I know people, not many, I am very pleased to say that will go and buy a dress and use it at the wedding and then return it. That doesn't fit. And maybe it doesn't fit because of all the food they ate at the wedding, but is that ethical? But the seller has to take it back. You have a very interesting case in your textbook, the Richardson case. And this is something to do about guns control. And the court had to draw the line when a consumer use of its product is abnormal one, and at the same time expected one. And there are cases, many times, you know, there's a case even, in a law firm, not in my law firm, but in a law firm where the lawyers did have a permit to have a gun, and the guys come over and take the gun from the drawer and start shooting people. I mean, will the manufacturer of guns be liable for that situation? Can they foresee that somebody's going to come over in your office and take your gun? Very interesting, very interesting. Please read the case, both the arguments of the majority and of the dissent, because again, the dissent is in conflict with the rule of the majority and its reasoning. And usually the dissent becomes the evolution of the law, or the evolution of the legal reasoning between 5 to 10 years of the majority. Somehow, some way, the dissent seems to be before his time, because as time goes on, of course, this is a 1987 case, and this is 2004, so we are leaning toward the dissent more than we're leaning toward the majority. But please read the case and post your discussion and your reasoning to the following question. Legally plausible, but not necessarily true, because you might not agree with that, but those are the reasoning that are plausible. That's going to make you win the case. Is the Derringer a defective product? After you read the case, you let me know, yes or no. It depends. Remember, it depends. Is it unreasonably dangerous? Well, again, what is unreasonably? Well, what is reasonable? Well, reasonable is what? When a group of people have little disagreement about the same issue. So if that group of people think it's unreasonably dangerous, and again, who is it? The majority, the 55%, 53, 61. What you read and you see on TV, the polls. Did it cause the plaintiff harm? The plaintiff harm, yes, you'll see in the case it did. Can you articulate any public policy reason for holding the gun manufacturer liable for this injury? What kind of public policy, for the good of society? Well, the one that I think about it is that, yes, you have a right to bear guns. There's no question, that's a constitutional right. But there's always somebody out there, the reasonable people, that says, hey, you know that there is always someone that, they lose their temper, or there's a leak in the attic, or they are emotional in that moment. They cannot deal with the stress and the pressure of work or whatever it is that you might terminate them, and next thing you know, they come back and kill you. So what public policy, and especially in the United States, when we encourage people to obey the law and not take a law in their own hands. And it's very easy to take law in your own hands when you own a gun. Assume that Richardson had been shot by a hunting rifle instead of a Derringer. Would your answers then to the above question be different? Compare the two, the hunting rifle. Here's people that go hunting, they have a set season to go hunt. As a matter of fact, in New Jersey, we had for a month permission to shoot deers because we have so many. Not anymore. That month they were allowed to do it, which was dangerous because I have deers in my backyard. What about if the injury was caused by accidental misfiring of the derringer? And lately we had the basketball player with the Williams case, where you can see that he shot, allegedly, the driver of his limousine. And you see how the expert testimony was coming to court, presenting doubt because it was a criminal case, that maybe the rifle was defective and that it shoot, and the thing pulled and shot the driver. All these things were very, very interesting. If it's accidental, then is the manufacturer of the rifle or the gun liable? The assignment. This is something that I'm asking you to do as your assignment, and I'm going to post this case on the discussion board. And the issue presented to the court was whether warnings are inadequate if the warnings were never read by the product user. And you know that the person got hurt, and next thing you know, sues the Kawasaki heavy industry, Kawasaki company, and the company says, how can the warning be inadequate when it was never read? And of course, I want you to reason why would be the warning inadequate, because somebody got hurt. And this is a distinguish the Rosen case with the Richardson case regarding ATVs, because in the Richardson case, when you read the opinion of the judge or the court, they are comparing the guns against the ATV. So it would be very interesting that I want you to compare those reasoning of the judges in Richardson case, and then use that reasoning with the Rosen case, and would that court apply the same reasoning with the case that I will post on the discussion board. Finally, which came first, the irrational consumer or the irrational corporation? I really would like to debate this. Which one? It's almost like which one came first, the eggs or the chicken? And in this situation, which one? Is it the irrational consumer? Come on, don't you have any common sense? I hear many, many times, and this is why at the beginning of the semester I gave you the article about the death of the common sense, because more and more we don't know if we have common sense. We don't know if we are a member of the reasonable people. Many times I find myself in contradiction with some of the people, colleagues at work. So who came first, the irrational consumer or the irrational corporation? That they come up with all kinds of products and they put them on commerce without thinking of the consequences of the people getting hurt. Or let's put it this way, even if people are going to get hurt, let's put the product for about 2 months on commerce, make our money, and move to another country, and we never get caught. So which one came first? I really always the irrational corporation reflecting the irrational consumer, because we are becoming all irrational lately, and we're looking for risk and excitement. So I really would like to hear you now. Thank you so very, very much.